Hello, I am Tommy the Legal Gun, and I'm here to show you how easy it is to win your case in the superior courts of any state you are in, as long as the state that you are in is alleging that they are the plaintiff. I first must say that this is not legal advice. If you are seeking legal advice, contact an attorney or a bar member. This is for entertainment purposes only. This is my motion that I filed in the state of Arizona, case number CR 219-0479. Motion to dismiss or strike for conflict of interest and no cause of action or corpus delicti. Now comes Thomas Joseph blank blank in the propria persona pro se by special appearance, not submitting to the court's jurisdiction, standing on my God-given constitutionally protected rights, pursuant to the affidavit of reservation of rights under UCC 1-207 and 308, filed with the clerk of the court in the Mojave County Courthouse. The foundation of the court's jurisdiction is the purpose of government itself. Governments are established to protect and maintain an individual's rights. Arizona Constitution, Article 1 of 1. The United States Constitution grants this court two different criminal jurisdictions in which to use. One is a criminal jurisdiction under the common law. The other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the United States Constitution. So my question is, in which of these two jurisdictions does this court intend to try me? Since the United States Constitution does not recognize Arizona revised jurisdiction, neither shall I. The Sixth Amendment grants me the right to know the jurisdiction in which to be tried and grants the judge with the duty of informing me. And I don't think you, Your Honor, would be in violation of your oath of office by doing your duty. I have to know the jurisdiction this court is operating under so that I may know the rules of procedure and be able to mount a presentable defense. Another problem I see with this complaint and a violation of my rights and liberties is if the state of Arizona is the plaintiff, how then can it be the judge and prosecutor? I demand this case be dismissed with prejudice and that I, Tommy the Legal Gun, be compensated for the time and money spent defending myself in this matter. Please allow me to define a word from the Black's Law Dictionary, 8th edition, oath. A solemn declaration accompanied by swearing to God that one's statement is true, or that one will be bound to a promise. The one making the oath implicitly invites punishment if the statement is untrue or the promise broken. The legal effect of an oath is to subject the person to penalties of perjury if the statement is false. Officers of the court are all oath-taking public servants. Article 6, Paragraph 2 of the United States Constitution. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary are notwithstanding in law. Allow me to quote a case from the United States Reports, Volume 5, page 137, from the year 1803, Marbury versus Madison. The opinion of the court was given by Chief Justice of the Supreme Court, Judge John Marshall. His opinion was, anything that is in conflict with the supreme law is null and void of law. It would bear no power to enforce, bear no obligation to obey. It would report to settle as if it never had existed. No court is bound to uphold it. No citizen is bound to obey it. One more from the United States Reports, Volume 118, page 425, Norton versus Shelby County. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is in legal contemplation, as imperative as though it had never been passed. Officers of the court have no protection or immunity when violating a creator-endowed, constitutionally protected right. Officers of the court, did you know when you violate a citizen's rights, you are guilty of Title 18, Part 1, Chapter 13, Section 242 and 243 of the United States Constitution, deprivation of rights under color of law. Anyone under color of law violates a creator-endowed, constitutionally protected right of any citizen shall be fined or imprisoned. Now that I have a solid foundation of constitutional law to stand on, with all my rights afforded me, none pro tunc, I must bring to light this prosecutor is in dishonor for violating his oath and the very essence of law that he should stand for. Allow me to define a word from the Black's Law Dictionary, 8th edition. Sham prosecution. A prosecution that seeks to circumvent a defendant's double jeopardy protection by appearing to be prosecuted by another sovereignty when it is in fact controlled by the sovereignty that already prosecuted the defendant for the same crime. This is the second time I've had to defend myself in this matter. Now let's take a look at this from the very basics of criminal law. How can the state of Arizona plead a cause of action when it is at best a fiction and not a person? No case, crime, or cause of action. This is why we have a case or cause of action. A plaintiff must plead the violation of a legal right. The duty of the courts, as of every judicial tribunal, is limited to determining rights of persons or of property, which are actually controverted in the particular case before it, Tyler versus Judges of the Court, registration. The basic elements of a crime or cause of action is the violation of a legal right and the loss or harm. The alleged plaintiff, a legal fiction at best, ostensibly acting through the officer that arrested you, has not pled any legal violation of a legal right or harm. Legally, there is no cause of action. A cause of action is some particular legal right of plaintiff versus defendant, Lucky versus McCall Manufacturing Company, and also Sowell versus Martin. This includes proceedings like these allegedly criminal in nature. Causation consists of two distinct sub-elements. As legal scholars have recognized, before a defendant can be convicted of a crime that includes an element of causation, the state must prove beyond a reasonable doubt that the defendant's conduct was, number one, cause in fact, and number two, the legal cause, or often called the proximate cause of the relevant harm. In order to establish that the defendant's conduct was cause in fact of a particular harm, the state usually must demonstrate that but for the defendant's conduct, the harm would not have occurred. State versus Emersley. It is a fundamental principle of law that no person be adjudged guilty of a crime until the state has shown that a crime has been committed. The state therefore must show that a harm has been suffered of the type contemplated by the charges. For example, in a death in the case of a murder charge, or loss of property in the case of a theft charge, and that such harm was incurred due to the criminal agency of another. Thus, it is sufficient if the elements of the underlying crime are proven rather than those of a particular degree or variation of that crime which may be charged. State versus Allen. Even if the absurd claim is made, harm is not a necessary element of a real crime. The complaint is still fatally flawed, as there is no accusation the alleged defendant violated anyone's legal rights. If there were a true adversary against the alleged defendant, it would be laughable to even try to discuss causation, because the defendant is not accused of causing anything real or imagined. No corpus delicti. The corpus delicti is the body of a crime itself. Virtually every American jurisdiction agrees. It's absolutely essential element of any crime and is consistent with the stated purpose of American governments. Corpus delicti is usually proven by the following two elements: injury or loss, and someone's criminal act as cause thereof. State versus Smith. Corpus delicti consists of injury or loss and someone's criminal act has caused it. State versus Espinoza. In every criminal trial, the prosecution must prove the corpus delicti or the body of a crime itself, i.e., the fact of the injury, loss, or harm, and the existence of a criminal agency as its cause. People versus Sapp. Also quoting People versus Alvarez. In defining corpus delicti, Wharton says it is made up of two elements. Number one, that a certain result has been produced, and number two, that someone is criminally responsible for that result. McVeigh versus State. In order to prove that a crime occurred, the state must prove beyond a reasonable doubt, number one, the basic injury, and number two, the fact that the basic injury was a result of a criminal rather than a natural or accidental cause. State versus Libero. Occurrence of injury or loss of harm and its causation by criminal conduct are termed the corpus delicti. People versus Assento. While the corpus delicti must be proved beyond a reasonable doubt, it may be established by circumstantial evidence. James versus State. Criminal responsibility is imposed on the basis of intentional doing of an act with awareness that the probability that the act will result in a substantial damage regardless of whether the injury turns out to be minor or insignificant. Combe versus Ruddock. The term corpus delicti embraces occurrence of loss or injury and the criminal causation thereof. State versus Hill. It has long been fundamental to the criminal jurisdiction of the Commonwealth that a necessary predicate to any conviction, if proof of the corpus delicti, i.e. the occurrence of an injury or loss, and someone's criminality as the source of the injury or loss. See Commonwealth versus Burns and Commonwealth versus Torza. The corpus delicti of a crime consists of two elements. Number one, the fact of the injury or loss or harm, and number two, the existence of a criminal agency as its cause. There must be sufficient proof of both elements of the corpus delicti beyond a reasonable doubt. American Jurisprudence, 2nd edition. This is not the same as the corpus delicti rule, which is not an element of an alleged crime, but a procedural rule. There is no corpus delicti pled in the complaint. Without a corpus delicti, there is no crime. Component parts of every crime are the occurrence of a specific kind of injury or loss, and somebody's criminality as a source of the loss, and the accused identity as the doer of the crime. The first two elements are what constitute the concept of corpus delicti. U.S. versus Shunk. Lack of jurisdiction. Standing represents a jurisdictional requirement which remains open to review at all stages of litigation. National Organization of Women, Incorporated versus Shelder. Because there is no corpus delicti, there is no crime. Yes, there is a so-called crime alleged on paper, but the allegation fails to meet every legal standard of what a crime is. Also, because American governments are established for the sole purpose of protecting rights, a true crime requires a violation of a legal right. Alleged defendant is not accused of violating anyone's legal right. Therefore, there is no crime, case, or cause of action pled, and the court has no jurisdiction. The complaint is unfit for adjudication. Because American courts are adversary systems, the complaint is unfit for adjudication. The Supreme Court has found unfit for adjudication any case that is not in any real sense adversary. That does not assume the honest and actual antagonistic assertion of rights to be adjudicated. Pohl versus Illman. The phrase corpus delicti is not used. There is no doubt this is not an adversary proceeding, and there is no allegation I violated any legal right, anyone's legal right. No evidence of a presence within the state, and laws are applicable. There are no facts pled to prove my presence within the plaintiff state of Arizona, and that the laws of the state are applicable to me. Such evidence is essential to prove jurisdiction. Mere geographic location is not evidence of presence within the alleged plaintiff state of Arizona. It's impossible to prove my presence within the alleged plaintiff state beyond a reasonable doubt or preponderance of evidence. The state of Arizona, while obviously not geographic, it is at best political, as it did not exist prior to February 14th, 1912. The phrase state of Arizona appears to be not much more than a DBA or synonym for lawyers and police officers. This will be shown if a state lawyer responds to this motion. As the laws of the state only apply within the state, there are no evidence and nothing alleged. The law of the state of Arizona apply to me. Since this is a criminal proceeding, then the assigned judge is obligated to presume my innocence until proven beyond a reasonable doubt. The Honorable Billy K. Sipes, Jr. may not assume the law is applicable now because it is an essential element of an alleged crime. Court jurisdiction. Not enlarged by police authority, the jurisdiction of the court is limited to protecting rights. This is not enlarged by alleging the police have authority to issue tickets. Such authority does not work to trump fundamental limitations on the courts. No amount of police authority may enlarge the limits of the adversary system. Adversary systems require true adversaries. This requires the allegation and proof of injury. The plaintiff has failed to make such allegations. Yes, police may have authority to issue tickets, to issue traffic tickets. Yes, police may have authority to issue traffic tickets. They must still allege injury for the court to proceed with jurisdiction. My conclusion. Because the plaintiff has failed to allege the required elements of what a cause of action/crime and that there is no corpus delicti, the court has no jurisdiction. As such, the court should either strike this complaint filed against me or dismiss it. Submitted this day, 15th of October, 2019. With this complaint that I argued in my case, the prosecution decided to rest and not pursue the matter any further. Case dismissed. If you would like any further case law on this argument, please contact me at my Gmail account, TommyJoseph5210 @gmail.com.